Welcome to this exam review from Birdsey, your AI-powered study partner. Be sure to like and subscribe for more videos, and don't miss what's happening in the lower corner of the screen. It could be just the thing you need to pass your exam. Let's get started.
Let's start with a basic review of Texas-specific laws in practice. TRELA and TREC compliance requirements and disciplinary rules. What is the primary function of the Texas Real Estate Commission? Is it A, to regulate real estate practices in Texas? B, to set national real estate standards? C, to provide legal advice to real estate agents? Or D, to manage real estate transactions? The answer is A, to regulate real estate practices in Texas. The TREC's main role is to regulate real estate practices in Texas, ensuring compliance with state laws and protecting consumers. Under TRELA, who is responsible for ensuring that a real estate agent's license is active and in good standing? Is it A, the broker? B, the Texas Real Estate Commission? C, the client's responsibility? Or D, the real estate agent themselves? The answer is D, the real estate agent themselves. Why this question may seem a bit tricky. It might seem like the broker or TREC would ensure this, but it's ultimately the agent's responsibility to maintain their license status. Sarah, a licensed real estate agent in Texas, is approached by a client to handle a transaction. She realizes her license expired last month. What should Sarah do to comply with TRELA? Is it A, proceed with the transaction and renew her license later? B, renew her license before proceeding with any transactions? C, ask her broker to handle the transaction on her behalf? Or D, inform the client she cannot assist due to personal reasons? The answer is B, renew her license before proceeding with any transactions. Sarah must renew her license before engaging in any real estate activities, as operating with an expired license violates TRELA. What action can TREC take if a licensee violates TRELA regulations? Is it A, issue a warning letter only? B, file a lawsuit against the licensee? C, suspend or revoke the license? Or D, require additional training without other penalties? The answer is C, suspend or revoke the license. TREC can impose disciplinary actions such as fines, suspension, or revocation of a license for violations. John, a real estate agent, receives a complaint from a client about a potential ethical violation. What is John's first step according to TREC guidelines? Is it A, review the complaint and respond appropriately? B, ignore the complaint if he believes it's unfounded? C, immediately contact TREC to resolve the issue? Or D, consult with a lawyer before taking any action? The answer is A, review the complaint and respond appropriately. John should review the complaint and respond appropriately, ensuring he follows TREC's guidelines for addressing complaints.
Have you noticed the code in the bottom corner? Next time you're stumped, take that code to birdsey.ai for immediate help and a free study session with Birdsey, your personal AI study partner. Plus, you'll get access to hundreds of additional questions, helping you move closer to passing your exam with confidence. The next time you're feeling unsure or stuck, give it a try.
Trust accounts, handling of client funds, and record-keeping rules. What is the primary purpose of a trust account in Texas real estate practice? Is it A, to earn interest for the broker? B, to keep client funds separate from the broker's funds? C, to reduce the broker's tax liability? Or D, to simplify accounting for the broker? The answer is B, to keep client funds separate from the broker's funds. A trust account is used to hold client funds separately from the broker's personal or business funds, ensuring that client money is protected and not commingled. In Texas, what must a broker do with earnest money received from a client? Is it A, deposit it in a trust account by the close of the second business day after the contract is executed? B, use it to cover immediate business expenses? C, hold it until the transaction closes? Or D, return it to the client immediately? The answer is A, deposit it in a trust account by the close of the second business day after the contract is executed. Why this question may seem a bit tricky, earnest money must be deposited in a trust account by the close of the second business day after the contract is executed, not simply held or used for other purposes. A Texas real estate broker receives a check from a client for a property transaction. The client requests that the check be held for a week before depositing. What should the broker do? Is it A, hold the check as requested by the client? B, deposit the check into the broker's personal account temporarily? C, deposit the check into a trust account by the close of the second business day? Or D, return the check to the client and ask for a new one later? The answer is C, deposit the check into a trust account by the close of the second business day. The broker must deposit the check into a trust account by the close of the second business day after receiving it, regardless of the client's request. Advertising regulations, disclosures, and team name rules. What must a real estate team name include according to Texas advertising regulations? Is it A, the name of the brokerage? B, the word team or group? C, the license number of the team leader? Or D, the city where the team operates? The answer is B, the word team or group. In Texas, a real estate team name must include the word team or group to clearly indicate that it is not an independent brokerage. Which of the following is a requirement for real estate advertising in Texas? Is it A, including the agent's personal phone number? B, displaying the agent's license number? C, including the broker's name? Or D, listing the property address? The answer is C, including the broker's name. Why this question may seem a bit tricky, the requirement to include the broker's name in all advertising is often confused with other elements like license numbers or team names. Sarah, a Texas real estate agent, wants to advertise her new listing on social media. What must she ensure is included in her advertisement? Is it A, her broker's name? B, her personal website URL? C, the listing price? Or D, a photo of the property? The answer is A, her broker's name. Sarah must include her broker's name in the advertisement as Texas law requires this for all real estate advertising. John's real estate team is rebranding and wants to use the name John's Realty Experts. What must they consider under Texas law? Is it A, registering the name with the Texas Real Estate Commission? B, including the city name in their branding? C, using the broker's name in the team name? Or D, adding team or group to the name? The answer is D, adding team or group to the name. John's team must include team or group in their name to comply with Texas regulations, which prevent misleading representations.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Promulgated contracts and forms. 1 to 4 family residential contract, obligations, deadlines, and contingencies. What is the primary purpose of the option period in the 1 to 4 family residential contract? Is it A, to finalize the mortgage approval process? B, to allow the buyer to terminate the contract for any reason? C, to negotiate the final sales price? Or D, to ensure the seller completes all repairs? The answer is B, to allow the buyer to terminate the contract for any reason. The option period allows the buyer to terminate the contract for any reason, providing a time frame to conduct inspections and due diligence. In the 1 to 4 family residential contract, what happens if the buyer fails to deliver the option fee within the specified time? Is it A, the buyer loses the right to terminate during the option period? B, the contract becomes void? C, the seller can terminate the contract? Or D, the buyer must pay a penalty? The answer is A, the buyer loses the right to terminate during the option period. Why this question may seem a bit tricky, the option fee must be delivered on time to secure the option period. If not delivered, the buyer loses the right to terminate the contract during the option period. If a buyer discovers a major defect during the option period, what is the most appropriate action according to the 1 to 4 family residential contract? Is it A, proceed with the purchase without any changes? B, immediately terminate the contract without negotiation? C, negotiate repairs or terminate the contract? Or D, request an extension of the option period? The answer is C, negotiate repairs or terminate the contract. The buyer can negotiate repairs or terminate the contract during the option period if a major defect is found. During the option period, what is the buyer's obligation if they decide to terminate the contract? Is it A, notify the seller verbally? B, pay an additional fee to the seller? C, complete all inspections? Or D, provide written notice of termination? The answer is D, provide written notice of termination. Why this question may seem a bit tricky, the buyer must provide written notice to terminate the contract during the option period, which is a common requirement that can be overlooked. A buyer and seller have agreed on a closing date, but the buyer's financing is delayed. What is the best course of action according to the 1 to 4 family residential contract? Is it A, proceed with closing without financing? B, request an extension of the closing date? C, cancel the contract and forfeit the earnest money? Or D, ignore the delay and hope for the best? The answer is B, request an extension of the closing date. The buyer should request an extension of the closing date to accommodate the financing delay, which requires mutual agreement. John and Mary are purchasing a home using the 1 to 4 family residential contract. They discover a title issue 2 days before closing. What should they do according to the contract? Is it A, proceed with closing as scheduled? B, terminate the contract immediately? C, request an extension of the closing date? Or D, ignore the issue and hope it resolves itself? The answer is C, request an extension of the closing date. The contract allows for an extension of the closing date to resolve title issues. This ensures both parties have time to address the problem without breaching the contract. Promulgated Addenda selection, use, and common misapplications. Which addendum is used to address the sale of a property that is contingent upon the sale of another property? Is it A, addendum for property subject to mandatory membership in a property owners association? B, addendum for sale of other property by buyer? C, third-party financing addendum? Or D, addendum for backup contract? The answer is B, addendum for sale of other property by buyer. The addendum for sale of other property by buyer is specifically designed for situations where the purchase is contingent on the sale of another property. When is the addendum for property located seaward of the Gulf Intracoastal Waterway required? Is it A, for any property near a body of water? B, for any coastal property? C, for properties seaward of the Gulf Intracoastal Waterway? Or D, for properties with water rights? The answer is C, for properties seaward of the Gulf Intracoastal Waterway. Why this question may seem a bit tricky, The addendum is required for properties located seaward of the Gulf Intracoastal Waterway, not just any coastal property. Sarah is selling her home, and the buyer wants to include a provision for the buyer to lease the property before closing. Which addendum should they use? Is it A, buyer's temporary residential lease, B, seller's temporary residential lease, C, addendum for sale of other property by buyer, or D, third-party financing addendum? The answer is A, buyer's temporary residential lease. The buyer's temporary residential lease is used when the buyer wishes to lease the property before closing. Which addendum is necessary when a buyer wants to terminate the contract if the property does not appraise for the sales price? Is it A, addendum for property subject to mandatory membership in a property owners association, B, addendum for sale of other property by buyer, C, addendum for backup contract, or D, third-party financing addendum? The answer is D, third-party financing addendum. The third-party financing addendum includes a provision for termination if the property does not appraise for the sales price. John is purchasing a property that is part of a homeowners association. What addendum should be included in the contract? Is it A, addendum for property subject to mandatory membership in a property owners association, B, addendum for sale of other property by buyer, C, third-party financing addendum, or D, addendum for backup contract? The answer is A, addendum for property subject to mandatory membership in a property owners association. The addendum for property subject to mandatory membership in a property owners association is required for properties in an HOA. Earnest money, option fee, delivery requirements, and timeframes. What is the primary purpose of earnest money in a real estate transaction? Is it A, to cover closing costs, B, to show the buyer's good faith, C, to pay for property inspections, or D, to secure a lower interest rate? The answer is B, to show the buyer's good faith. Earnest money is a deposit made to demonstrate the buyer's serious intent to purchase the property, providing the seller with assurance of the buyer's commitment. If a buyer fails to deliver the option fee within the specified time frame, what is the most likely consequence? Is it A, the contract is automatically voided, B, the seller must return the earnest money, C, the buyer loses the right to terminate during the option period, or D, the buyer must pay a penalty fee? The answer is C, the buyer loses the right to terminate during the option period. Why this question may seem a bit tricky. The option fee is crucial for securing the option period. Without timely delivery, the buyer loses the right to terminate the contract during the option period. John, a buyer, delivers the earnest money to the title company 2 days after the deadline specified in the contract. What is the potential impact on the transaction? Is it A, the seller may terminate the contract for breach, B, the contract automatically extends the deadline, C, the buyer must pay an additional fee to continue, or D, the earnest money is forfeited? The answer is A, the seller may terminate the contract for breach. The late delivery of earnest money can lead to a breach of contract, allowing the seller to terminate the agreement or negotiate new terms. Sarah, a seller, receives the option fee from the buyer but not the earnest money by the due date. What should Sarah do to protect her interests? Is it A, ignore the issue and proceed with the sale, B, return the option fee to the buyer, C, demand immediate payment of the earnest money, or D, notify the buyer of the breach and consider termination? The answer is D, notify the buyer of the breach and consider termination. Sarah should notify the buyer of the breach and consider terminating the contract or negotiating new terms as the earnest money is crucial for the contract's validity. Agency and brokerage operations. Intermediary representation, appointments, and disclosure duties. What is the primary duty of an intermediary in a real estate transaction? Is it A, to advocate for the buyer's best interests, B, to remain neutral and facilitate the transaction, C, to ensure the seller receives the highest price, or D, to provide legal advice to both parties? The answer is B, to remain neutral and facilitate the transaction. An intermediary must remain neutral and not favor either party in the transaction, ensuring fair treatment for both the buyer and seller. When must an intermediary disclose their role to the parties involved in a transaction? Is it A, after the contract is signed, B, during the closing process, C, before substantive discussions about the transaction, or D, only if asked by the parties? The answer is C, before substantive discussions about the transaction. Why this question may seem a bit tricky. The timing of disclosure is crucial and often misunderstood. Disclosure must occur before any substantive discussions about the transaction. A real estate agent is representing both the buyer and seller in a transaction. What must the agent do to comply with intermediary representation rules? Is it A, obtain written consent from both parties, B, advocate for the party offering the higher commission, C, disclose the highest offer to both parties, or D, provide legal advice to ensure fairness? The answer is A, obtain written consent from both parties. The agent must obtain written consent from both parties to act as an intermediary, ensuring both are aware and agree to the dual representation. What is required for an agent to act as an intermediary in Texas? Is it A, verbal agreement from both parties, B, a separate contract with each party, C, approval from the broker only, or D, written consent from both parties? The answer is D, written consent from both parties. In Texas, an agent must have written consent from both parties to act as an intermediary, ensuring both parties are informed and agree to the arrangement. During a negotiation, a buyer's agent learns confidential information about the seller. What should the agent do if acting as an intermediary? Is it A, share the information with the buyer to gain an advantage, B, keep the information confidential and not disclose it, C, discuss the information with both parties to ensure transparency, or D, report the information to the broker for further action? The answer is B, keep the information confidential and not disclose it. The agent must not disclose confidential information to the other party, maintaining neutrality and confidentiality as required by intermediary rules. Fiduciary duties, confidentiality, and client versus customer distinctions. What is the primary fiduciary duty an agent owes to their client? Is it A, confidentiality, B, loyalty, C, disclosure, or D, reasonable care? The answer is B, loyalty. The primary fiduciary duty an agent owes to their client is loyalty, which means putting the client's interests above all else, including the agent's own interests. Which duty is an agent not required to provide to a customer? Is it A, honesty, B, fairness, C, loyalty, or D, disclosure of material facts? The answer is C, loyalty. Why this question may seem a bit tricky. Customers often confuse the duties owed to them versus clients. Agents owe honesty and fairness to customers, but not loyalty, which is reserved for clients. An agent is representing a seller and learns confidential information about the buyer's financial situation. What should the agent do with this information? Is it A, share it with the seller to gain negotiation leverage? B, use it to adjust the listing price? C, discuss it with other agents to get advice? Or D, keep it confidential and not disclose it? The answer is D, keep it confidential and not disclose it. The agent must maintain confidentiality and not disclose the buyer's financial situation, as it is not relevant to the seller's interests and could breach fiduciary duties. A buyer's agent learns that the seller is desperate to sell quickly due to financial issues. How should the agent handle this information? Is it A, use it to negotiate a better price for the buyer? B, keep it confidential to maintain fairness? C, inform the seller's agent to maintain transparency? Or D, ignore it as it is not relevant to the transaction? The answer is A, use it to negotiate a better price for the buyer. The agent should use this information to benefit the buyer, as it is part of their fiduciary duty to act in the best interest of their client.
Notice the code in the corner? When you're stumped by a question, enter it at birdsey.ai for immediate help. Enjoy complimentary study sessions and access to hundreds of additional questions to help you pass your exam with confidence.
Brokerage policies, representation agreements, and notice requirements. What is the primary purpose of a representation agreement in real estate brokerage? Is it A, to set commission rates for the agent? B, to provide a marketing plan for the property? C, to establish the legal relationship between agent and client? Or D, to outline the property's listing price? The answer is C, to establish the legal relationship between agent and client. A representation agreement establishes the legal relationship and duties between a real estate agent and their client, ensuring both parties understand their obligations. In a brokerage agreement, what is typically required for a notice to be considered valid? Is it A, verbal communication between parties? B, written communication as specified in the agreement? C, any form of communication agreed upon verbally? Or D, electronic communication only? The answer is B, written communication as specified in the agreement. Why this question may seem a bit tricky, notices often require specific delivery methods to be valid, such as written form, which can be overlooked if verbal communication is assumed sufficient. A seller's agent receives an offer on a property but is unable to reach the seller immediately. What is the agent's obligation regarding the offer? Is it A, present the offer to the seller as soon as possible? B, wait until the seller contacts them to discuss the offer? C, reject the offer if it seems too low? Or D, negotiate with the buyer's agent before informing the seller? The answer is A, present the offer to the seller as soon as possible. The agent must present all offers to the seller as soon as possible, ensuring the seller is informed and can make timely decisions. Finance and real estate math. Loan types, qualifying rules, and Texas-specific finance considerations. What is the maximum loan-to-value ratio typically allowed for a conventional loan? Is it A, 70%, B, 75%, C, 80%, or D, 85%? The answer is C, 80%. Conventional loans usually allow a maximum LTV of 80%, meaning the borrower must provide a 20% down payment. In Texas, which type of loan allows for the highest loan-to-value ratio without requiring mortgage insurance? Is it A, FHA loan, B, VA loan, C, conventional loan, or D, USDA loan? The answer is B, VA loan. Why this question may seem a bit tricky. VA loans allow for 100% financing without mortgage insurance, unlike FHA or conventional loans. Waria is buying her first home in Texas and wants to qualify for a loan with a low down payment. Which loan type should she consider? Is it A, FHA loan, B, conventional loan, C, VA loan, or D, jumbo loan? The answer is A, FHA loan. FHA loans are popular for first-time buyers due to their low down payment requirements, typically as low as 3.5%. John, a veteran, is looking to buy a home in Texas with no down payment. Which loan should he apply for? Is it A, FHA loan, B, VA loan, C, conventional loan, or D, USDA loan? The answer is B, VA loan. VA loans are specifically designed for veterans, allowing them to purchase homes with no down payment. Closing cost calculations, prorations, and settlement statements. What is the purpose of a settlement statement in a real estate transaction? Is it A, to determine the property's market value, B, to calculate property taxes for the next year, C, to itemize all financial transactions between buyer and seller, or D, to provide a legal description of the property? The answer is C, to itemize all financial transactions between buyer and seller. A settlement statement provides a detailed breakdown of all costs and credits involved in a real estate transaction, ensuring transparency for both buyer and seller. If a buyer closes on a property on June 15th, how are property taxes typically prorated? Is it A, the buyer pays all taxes for the year, B, the seller pays taxes up to the closing date, C, taxes are not prorated and are paid by the seller, or D, the buyer and seller split the taxes equally? The answer is B, the seller pays taxes up to the closing date. Why this question may seem a bit tricky. Prorations are based on the assumption that taxes are paid in arrears, meaning the seller is responsible for taxes up to the closing date. John is buying a house and the closing date is set for March 1st. The seller has already paid the annual property taxes of $3,600. How much should John reimburse the seller for the taxes? Is it A, $3,000, B, $600, C, $1,800, or D, $2,400? The answer is A, $3,000. John should reimburse the seller for the taxes from March 1st to December 31st, which is 10 months. The prorated amount is $3,000. Which of the following is typically included in closing costs? Is it A, monthly mortgage payments, B, homeowners insurance premiums, C, property maintenance fees, or D, title insurance fees? The answer is D, title insurance fees. Closing costs often include fees such as loan origination, title insurance, and appraisal fees, which are necessary to complete the transaction. Sarah is selling her home and the buyer requests a closing date of December 15th. The annual HOA fee of $1,200 has been paid by Sarah. How much should the buyer reimburse Sarah for the HOA fee? Is it A, $100, B, $1,200, C, $50, or D, $600? The answer is C, $50. The buyer should reimburse Sarah for the HOA fee from December 15th to December 31st, which is half a month. The prorated amount is $50. Property taxes, exemptions, and assessment calculations. What is the primary purpose of a homestead exemption in property taxes? Is it A, to increase the market value of the property, B, to reduce the taxable value of a primary residence, C, to provide a tax credit for property improvements, or D, to defer property taxes until the sale of the property? The answer is B, to reduce the taxable value of a primary residence. A homestead exemption reduces the taxable value of a primary residence, lowering the property tax owed. It is not intended to increase property value or provide tax credits. If a property is assessed at $200,000 and the tax rate is 2.5%, what is the annual property tax? Is it A, $4,500, B, $6,000, C, $5,000, or D, $5,500? The answer is C, $5,000. Why this question may seem a bit tricky, the tax rate must be applied to the assessed value, not the market value or any other figure. The correct calculation is $200,000 times 0.025 equals $5,000. John owns a property assessed at $250,000 with a homestead exemption of $25,000 and a tax rate of 3%. What is his annual property tax? Is it A, $6,750, B, $7,500, C, $7,250, or D, $6,500? The answer is A, $6,750. The taxable value is $250,000 minus $25,000 equals $225,000. The tax is $225,000 times 0.03 equals $6,750.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Property disclosures and ownership issues. Seller's disclosure notice, requirements, and exemptions. Which of the following is a requirement for a seller's disclosure notice in Texas? Is it A, disclosure of the seller's financial status, B, disclosure of known material defects in the property, C, disclosure of neighborhood crime rates, or D, disclosure of the seller's reason for selling? The answer is B, disclosure of known material defects in the property. In Texas, sellers are required to disclose any known material defects in the property. This ensures that buyers are aware of significant issues before purchasing. A seller is exempt from providing a seller's disclosure notice if the property is being transferred to a spouse. What might be a common misconception about this exemption? Is it A, the exemption applies to all family members, B, the exemption applies to all types of property, C, the exemption applies specifically to transfers to a spouse, or D, the exemption applies to properties under a certain value? The answer is C, the exemption applies specifically to transfers to a spouse. Why this question may seem a bit tricky. It's easy to assume that all family-related transfers are exempt, but only specific relationships like transfers to a spouse qualify for this exemption. John is selling his home and has recently repaired a leaky roof. He is unsure if he needs to disclose this repair on the seller's disclosure notice. What should John do? Is it A, disclose the repair on the seller's disclosure notice, B, omit the repair since it has been fixed, C, only disclose if the buyer asks about the roof, or D, consult with a real estate attorney before deciding? The answer is A, disclose the repair on the seller's disclosure notice. John should disclose the recent roof repair as it pertains to the condition of the property, ensuring transparency with potential buyers. Environmental hazards, stigmatized properties, and material fact disclosures. What is a material fact that must be disclosed in a real estate transaction? Is it A, the seller's reason for moving, B, presence of lead-based paint, C, the seller's financial situation, or D, the neighborhood's crime rate? The answer is B, presence of lead-based paint. A material fact is any information that could influence a buyer's decision to purchase a property. This includes structural issues, environmental hazards, or legal encumbrances. Which of the following is not considered an environmental hazard that must be disclosed? Is it A, mold, B, asbestos, C, radon, or D, electromagnetic fields? The answer is D, electromagnetic fields. Why this question may seem a bit tricky. Mold, asbestos, and radon are well-known hazards requiring disclosure. Electromagnetic fields are less commonly recognized as a hazard needing disclosure. John is selling his house and knows that a violent crime occurred there years ago. Is he legally required to disclose this to potential buyers? Is it A, yes, always disclose past crimes? B, no, never disclose past crimes? C, only if asked by the buyer? Or D, only if the crime was recent? The answer is C, only if asked by the buyer. In many jurisdictions, sellers are not required to disclose stigmatized property issues like past crimes unless specifically asked by the buyer. Texas water rights, mineral rights, and surface estate issues. In Texas, who generally holds the rights to groundwater beneath a property? Is it A, the state government, B, the landowner, C, local water districts, or D, federal government? The answer is B, the landowner. In Texas, groundwater rights are typically held by the landowner under the rule of capture, allowing them to pump and use the water beneath their land. John owns a piece of land in Texas and discovers oil beneath it. However, he sold the mineral rights to a company years ago. What is John's entitlement regarding the oil? Is it A, he can extract the oil himself? B, he can claim a portion of the oil profits? C, he has no entitlement to the oil? Or D, he can negotiate a new agreement with the company? The answer is C, he has no entitlement to the oil. John cannot claim the oil because he sold the mineral rights, which include the rights to extract oil and gas from the land. Land use, contracts, and general real estate principles. Contract validity, enforceability, termination, and common mistakes. What is required for a real estate contract to be considered valid? Is it A, mutual consent, lawful object, consideration, and competent parties? B, mutual consent, lawful object, and a witness? C, consideration, competent parties, and notarization? Or D, lawful object, mutual consent, and a written document? The answer is A, mutual consent, lawful object, consideration, and competent parties. A valid real estate contract requires mutual consent, a lawful object, consideration, and competent parties. Without these elements, the contract may not be enforceable. Which of the following could render a real estate contract unenforceable? Is it A, mutual consent was obtained? B, the contract was not in writing? C, the parties were competent? Or D, the contract had a lawful object? The answer is B, the contract was not in writing. Why this question may seem a bit tricky. The term unenforceable can be confused with invalid. A contract may be valid but unenforceable if it lacks a necessary formality, like being in writing under the statute of frauds. John and Mary signed a real estate contract, but Mary later discovered that John was a minor at the time of signing. What is the status of the contract? Is it A, the contract is valid and enforceable? B, the contract is void? C, the contract is voidable? Or D, the contract is automatically terminated? The answer is C, the contract is voidable. A contract signed by a minor is voidable at the minor's discretion. Mary can choose to void the contract due to John's lack of legal capacity. land use controls, zoning authority, and private restrictions. What is the primary purpose of zoning laws in real estate? Is it A, to increase property taxes, B, to regulate land use and ensure orderly development, C, to provide funding for public schools, or D, to determine property ownership rights? The answer is B, to regulate land use and ensure orderly development. Zoning laws are designed to regulate land use and ensure that land is used in a way that is consistent with community planning goals, such as separating residential areas from industrial ones. A homeowner in a residential neighborhood wants to open a small bakery in their home. What zoning-related action must they take first? Is it A, start the business without any formalities, B, notify neighbors about the business, C, register the business with the local chamber of commerce, or D, apply for a zoning variance or special use permit? The answer is D, apply for a zoning variance or special use permit. The homeowner must apply for a zoning variance or special use permit to legally operate a business in a residential zone. Estates in land, forms of ownership, and property rights bundles. John and Mary are joint tenants in a property. John decides to sell his interest to Alex. What is Alex's ownership status after the sale? Is it A, joint tenant with Mary, B, tenant in common with Mary, C, sole owner of the property, or D, life tenant of the property? The answer is B, tenant in common with Mary. In joint tenancy, selling an interest severs the joint tenancy. Alex becomes a tenant in common with Mary, who retains her joint tenancy rights with the remaining owners, if any.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsey.ai to start your free trial of Birdsey, your AI-powered study partner.